This is Invisible Inc., the podcast for underserved women entrepreneurs. And I'm your host, Shubha Chakravarti, founder of Achieve. In this podcast, I talk to women entrepreneurs at every stage of their journey about the challenges, the highs, the lows, and what they've learned along the way. We'll also hear from experts who share valuable tips on how to succeed the smart way. Let's jump in. What is intellectual property? And why should you care? Especially as an entrepreneur who's just starting out. How can you protect your hard work and your investment in your business from undue risk? What can you do right now to get a head start? How should you select a good IP attorney? In this episode, business attorney Lisanne Butterfield discusses her views on all these questions and more. Please note that the information and content in this episode are not intended as legal advice for any specific person or entity. Please seek legal counsel before taking any action. For a full disclaimer, please check out the show notes page for this episode. So, Lisanne, thank you for joining us today. I'm really delighted that you agreed to talk to us.
It is my pleasure.
I know that you specialize in intellectual property, and there's a lot of confusion, not a lot of knowledge around just the term intellectual property. We hear about trademarks. Can you maybe give us a little primer for those of us who are not up to speed on what all of these terms mean and what we should know as entrepreneurs?
Absolutely. These terms are commonly interchanged, but trade secrets and trademarks and trade names and copyrights truly are distinctly different legal animals. And before any business owner invests her time or energy and resources in branding or marketing, it's prudent to think about whether or not she wants to protect her trade secrets and her trade names. So the difference generally is a trade secret is anything that gives a business owner or an entity an economic advantage. So something that the business owner invested time, energy, and resources in protecting. A trade secret is something that gives the business owner an economic and competitive advantage over others in that space. A trade name is typically something that's recognized in the law to protect a name or a symbol that a business uses to sell and market her services and or products. A copyright is something that protects, it could be a song or a play or music or a piece of art. So something that has value that the inventor wants to protect from infringing. And that lasts typically a very long time, 70 years or perhaps longer under certain circumstances.
So today we're in the creator economy and a lot of businesses are internet-based. Where does copyright intersect with content and media businesses online, especially if you're a TikTok creator today? Is that a copyright? Is that a trade secret? And how would I know as a beginning entrepreneur? There may be somebody who's running a site, just any kind of content. Maybe they talk about how to live a minimalist life, but what you're producing is content and it's your unique content because you have a brand name. People recognize you as XYZ versus somebody else who's writing presumably about the same subject, and you put in time and effort to create this content. Is that copyrightable, or is that something else that should apply?
The content that the business owner is creating is protected by copyright law. So that's the actual artistic expression, if you will, the photograph, the article, the website design, the information on the blog, for example. Whereas the trade name is the manner in which the business owner is marketing and distributing her service or good. The trade secret is something we talked about earlier, is more of the secret sauce behind how she may have created that.
The one thing I'm also going to probe is you talked about trade name. Where does brand and this whole intellectual property law intersect, and what should a beginning entrepreneur or any business owner be thinking about in terms of their brand as it relates to intellectual property?
Their brand is part of their intellectual property because the business owner created the manner in which they're going to market, sell, leverage their secret sauce or their professional services or the creative license. So the brand can be protected under the intellectual property laws. The brand can be protected through private contracts as well. For example, if you and I decide that we're going to collaborate on developing content for your newsletter, you and I might decide amongst ourselves that we're going to enter into an agreement where we both have shared rights to that intellectual property, whether it be copyright and or trade name, the way in which we market it. And then if a third party then comes along and infringes upon that, that protects us and gives us a basis upon which that we can limit or prohibit third parties who haven't invested in protecting that from using it.
So this whole aspect of whether it's copyright or trademarks is not just something that big companies do later, but it sounds like it's something that I should think about day one as any kind of entrepreneur or business owner. Is that something you'd agree with?
Absolutely. As soon as you're at the point where you're beginning to invest time, energy, and resources, you ought to be thinking about, number one, is anybody out there using either your brand or the manner in which you're going to market it by way of a symbol or an image? And number two, is anybody else out there having registered the trade name, the trademark, or the copyright? Because before you get too far down the path, you want to make sure you're not infringing on somebody else's rights. And then that's not always a black and white inquiry as well, because then you have to be thinking about, what is your marketing channel? What is your region? Are you going to be offering your services and or product on the West Coast, for example, or in the Midwest or across the country? And so that might color your decision about whether, for example, you're going to register your trademark in one or two or a few states versus on the nationwide basis through the United States Patent Trademark Office.
Can you tell us a story that maybe pops into your mind about somebody who missed this, or some damage that was incurred, or the risk of just not paying attention early enough in the game to intellectual property?
Yes, that's a great question. Because as you know, a lot of what we do here at our firm is we represent registered investment advisors and dentists and doctors and realtors, other licensed professionals. And so sometimes they get down this path where they come up with a brand name, for example, and they begin to develop a client base, market their services, but they don't on the front end find out if there are competing providers. By that, I mean people who are using the same or similar trade name to provide the same or similar services. And so the risk then is there's consumer confusion, where a consumer may assume that, using a dentist as an example, dentist X in Portland, who's offering dental services, is affiliated with dental Y in Texas just because they have a similar name. And then if somebody gets licensed, disciplined, or has license revocation, or has something less than a stellar reputation, that consumer confusion can be negative. It could be negative consumer confusion. The same is true on the other side of it, because if a licensed professional goes down the path of incorporating in a few states and developing a website, developing business cards, branding, and doesn't take the time to figure out if that name is already in use, they've already spent all that time, energy, and money, even perhaps consulting with a lawyer to create organizational documents, entity formation documents, paying state licensing fees, even getting E&O insurance, all under the name of something they later have to change. And so I guess in a nutshell, it just makes a whole lot of sense on the front end, maybe not on day one, but before you get too far along in investing time, energy, and money, to, number one, confirm if that name is already taken. And if it's taken, what has that other provider done to protect it? I mean, do you just know that it's taken because you did a Google search and it looks like they might be offering the same or similar services on the East Coast and you're on the West Coast? Well, maybe that's not the end of the story. Maybe then you can beat them to the punch and get registered in your region and or on the national level through the USPTO. But that's going to color your decision. And so making those inquiries on the front end, preliminarily with information that's publicly available and free, perhaps to the licensed professional or the business owner by checking on Google, but then secondarily, hiring a third-party vendor to run a search report, because that information is going to help color and guide the business owner about what steps she may want to take to protect her business or shift gears, or know going into it, okay, I know there's this other provider in New Jersey, but she's offering something slightly different. Or if you're really invested in using that trade name or trademark, there's an opportunity to do a shared use agreement, which is also very typical, where you reach out to the provider and say, I see you're in New Jersey offering a similar product. I'd like to cooperate or negotiate with you to come to terms that work for both of us. Here's my proposal. Like perhaps I either pay you X, like a licensing fee, or we have a shared use agreement where you pay me Y. So there's options to do that. But the information is very valuable on the front end before you spend too much time, energy, and money. And then the other big risk is if you don't do that investigation, you may find yourself embroiled in a lawsuit, which would be very, very costly to defend.
So I'm getting the sense that there's a tendency, and I certainly fell prey to this early on, that This is a legal issue. And I think what I just learned from listening to you now is it's not strictly a legal issue. There's a business issue. Yes.
That's exactly right. That's exactly right.
What are the areas that, not being a lawyer, if I'm just a busy business owner, what are the areas that an entrepreneur needs to look at and at least have a basic fluency or familiarity with in this area?
Getting a legal opinion or helping yourself figure out the viability of your chosen name is, I think, one of the very first steps you want to be thinking about. And then, of course, registering your business. So registering your business is one path, but then registering your trade name is a different path. And you can do that registration on a state level or a federal level, like we talked about. As a layperson, you can certainly do it on your own, but lawyers are obviously skilled in providing the necessary information on an application to have a higher viability of the application being approved, which is very important. And so to your question, what should you do at the beginning? Checking the viability of whether or not your trade name is in use, creating formal written agreements with those with whom you're doing business with, like, for example, a non-disclosure agreement, a confidentiality agreement, a promise, a written contract between two parties that if for whatever reason you separate, the business owner will retain exclusive rights to the intellectual property. So those are the basic steps. I also think it's very important to make sure that you have formal written agreements with just about everybody that you're doing business with as an employee or an independent contractor or even a consultant, so that you spell out on the front end what the expectations are and what your rights are as a business owner to prohibit the infringement or the improper use by that consultant or employee after they separate from you, because you're giving them access to your secret sauce. You're giving them access, for example, to perhaps your client lists. You're giving them access to your pricing, to the way in which you market your services, to the way in which you developed your services. All that stuff that you're giving your colleagues, your consultants, your agents, your contractors, your employees, you need to be thinking about on the front end, how are you going to protect that if things go south or for whatever reason you ultimately decide to separate?
And that raises actually two questions that just popped in my mind based on that. The first is, a lot of bootstrapping entrepreneurs like myself, we use a lot of these platform-based services because they're cost effective. So for example, I might go to Fiverr to get a logo. I'm using these services to commission logos, to design my website in a particular way that makes it recognizable. What should I do to protect myself?
I mean, I think the best thing to do to start is reading their service contract, because presumably they have one. Perhaps you don't even realize it when you're clicking on the link to do business with them. You know, we're also guilty of that. Yes, but obviously reading carefully, even though there's a lot of arcane legalese in there, reading what they say their agreements are and what rights they're retaining. And there might be opportunities to cross out or negotiate those terms if you have some leverage about doing business with them. But the other flip side of that is to create your own service agreements. They don't have to be complicated, but it's important to be thinking about, as a business owner, what are you trying to restrict others from doing who you do business with? Like we talked a little bit about independent contractors and people who work for you, but the same is true for other outside vendors. You need to be thinking about, if you're giving them access, again, to your image or your contact or your secret sauce, then you need to protect your work. It's called work for hire. If they're creating work by request and hiring by you, then you need to protect your rights in retaining exclusive ownership.
One other follow-up question to that is, if I'm a starting business owner or a starting entrepreneur, there are things I do because I just do them. So as a business entrepreneur or a business owner, what is a good way to get a handle on this list of things that would qualify as trade secrets so that I can start having my mind trigger every time I'm touching one of those areas?
That's a great question. And I'm very glad you asked that, because I do think it's something that people sort of get away from. So generally speaking, anything a business owner is investing resources to protect from the public, something that sets you apart, something that makes you more competitive vis-a-vis the other people in your field providing the same or similar services. Those are the type of things, information. It could be digitally stored. It could be even verbal communications you've exchanged. Those are the type of things you want to be thinking about protecting. So not everybody has client lists that they're worried about protecting, and I appreciate that. But even if you choose to market or use, what's it called? Testimonials on your website from chosen clients who give you authority, that's not the same as saying that you wish to have public disclosure of all your clients' lists, because then other people may poach that or solicit that. So client list is one example, but another list is the way you might structure your pricing or market analyses that you may have performed before you launched. Anything that you have elected as a business owner to protect from public disclosure, that's probably a secret sauce. Even in this field, though, there are cases, and I actually have had cases about this, that publicly available information can also be a secret sauce and a trade secret if the business owner invested time, energy, and talent to compile it, codify it. If you just look up all the companies out there that provide internet services, for example, but if you as a business owner took the time to figure out which internet services are particularly adept at one particular aspect, or doing business in a particular region, or specialize in certain security features, then that compilation is your secret sauce that you're entitled to protect against public disclosure, and that you're entitled to protect as a employer when you have subordinates to whom you're giving access. So when you give your subordinates access, you also need to be thinking about, what do you want to do as a business owner to limit the risk that when your employees leave or your contractors leave, they will not infringe upon your rights in that respect. You gave them access while they were still affiliated with you, but you want to preclude them or limit their ability to use that access after they leave. So those are the things you want to be thinking about. So having everybody you work with, who you're giving access to, sign a confidentiality agreement on the front end is very, very important. And that brings me to another point. People often confuse or conflate the concept of a non-solicit, a confidentiality agreement, and a non-compete. In the eyes of employment law and business contract lawyers like myself, we call all of those collectively restrictive covenants, because they are contract provisions that limit or restrict the ability of the contracting parties to do something, either during employment and or after employment or association. The confidentiality agreement is something that protects the business owner from keeping all that confidential information to the business owner's own use during and after affiliation with the employee. A non-solicitation provision, of course, limits or restricts those who you do business with, employees, from soliciting your customers and or soliciting your the co-employees and or soliciting other vendors that you do business with. The non-competition agreement is typically a restriction that limits an employee or even a co-business owner's ability to compete for business while they're still affiliated with you and or after they leave. There's restrictions across the country in different states about the viability and enforceability of non-competes in certain industries and for certain employees.
So this is actually very practical for me, because what I'm taking away is, if I'm a business owner or an entrepreneur, the first thing I do is I literally can look at my calendar of what I did over the last few months and said, where did I spend time? And anything that I spent time, for example, I would have never thought of compiling a list, which a lot of business owners might do. For example, if you're catering to people with celiac, a list of products that are celiac friendly, and that's publicly available information. But right. I now realize that it's yours to protect. So that was pretty informative for me, because I hadn't thought about those covenants in terms of everyday businesses like your next door bakery or your retail clothing store, for example, where you make your own custom jewelry and things like that. Thank you.
Some of my favorite examples, because people say, help me understand trade secrets. What is a secret sauce? Coca-Cola's secret formula for making Coca-Cola, or Little Big Burger, that's a chain here in the Pacific Northwest. They have the most wonderful truffle flavored French fries. So their recipe for making truffle flavored French fries is their secret sauce. That's their trade secret. So even though they have people who are actually flipping burgers serving French fries, they can legitimately require those workers to sign an agreement that says they will not violate or misuse the secret sauce recipe, the truffle fry recipe. So I think those are the most helpful examples that people probably don't realize. You're interfacing with trade secrets all the time.
But I'm a bare bones beginning entrepreneur. So what advice would you give and what pointers would you give to a bare bones entrepreneur? What is a basic minimum list of things I have to watch out for and protect in terms of intellectual property?
Well, I'd say first, go back to the basics, as you said, formalize your business plan, identify your existing and prospective intellectual property rights, trade secrets, the secret sauce that we talked about. Consider to whom you're going to grant access. Is that going to be your employees, your vendors, your prospective business owners, obviously your CPAs and other professionals that you seek consultation with? And then I guess the third thing is think about whether or not you need formal employment agreements that may include one or more of the restrictive covenants that we earlier talked about. And that's something that you should probably think about revisiting on at least an annual basis. Just like you go and you get your teeth cleaned, do an evaluation, a self-audit, a self-exam, as we sometimes call it, and think to yourself, do I have the contracts I need to protect my intellectual property, to protect from disclosure my trade secrets, to protect from disclosure the solicitation that may happen after somebody leaves? The fourth thing is conduct due diligence to determine, before you get too far down the path, if there are competing businesses that are using your prospective or existing intellectual property or trade secrets. And again, that's something you want to do on an annual basis. You have a responsibility as a prudent business owner to not only look at this at the front end, but to be vigilant and protect your intellectual property as you continue to do business. And in fact, your failure as a business owner to be vigilant to protect your intellectual property dilutes the viability of your intellectual property. Said differently, if you invest more time, energy, and money to be vigilant and protect your intellectual property, you're going to have a better chance down the road because you're going to make the argument, look at all this time, energy, and money I've invested through the years to continue to, be my own police monitor on this. I have negotiated shared use agreements. That other entity that I talked about in New Jersey, I know they're using my name, but we came to agreement, and that's why they're allowed to use my name, because they paid me compensation. So I'd say that would be the fourth thing to think about, is who's out there using your intellectual property and what are you going to do to protect it? And then the fifth thing would be thinking about whether or not you're going to register your trademarks and trade names on the state and or federal level.
Are there like principles or guidelines as you are going about this, kind of like rules of thumb that you've found helpful to people who are not legal experts to keep in mind as they navigate this whole area of IP?
I guess generally you have to just keep checking who else is out there competing in your space or your prospective space. So I know we talked about, for example, ordering a third-party search report, but getting an amended report every year or 2 or 3, or at a minimum, checking online every now and then. See who is out there or who came on the horizon since the last time you checked, to make sure that what you're doing is not being infringed upon. And then I suppose the other thing is the whole adage, the whole conventional wisdom is take a long time to hire. And when you fire, do it quickly, meaning take your time and make sure you're vetting the people to whom you're going to give access. And then when you discover or even have a hunch that somebody's infringing upon your intellectual property rights or interfering with your trade secrets, breaching your confidentiality, you should move with deliberate haste to terminate those relationships, because the longer you wait, the more likely it is that you're exposing yourself to risk, and the more difficult it probably will be to defend your decision.
Now, let's say I've been in business for a while. For whatever reason, I haven't done the work. What do I do now, given that I've invested money? I potentially have put in a lot of time, emotional investment in my brand, but I have not taken the steps because I didn't know. Is there anything different that you would recommend? Because I've already invested all this time and I've been running my bakery, for example, for 5 years now. What do I do now?
I think it's never really too late. In a perfect world, you would take these prudent business steps on the front end, because then you could have shifted gears and maybe rebranded or reconsidered your marketing plan and maybe limited your region, for example. But if you've already started a bakery and you're already far down the path, absolutely it makes a lot of sense to continue to evaluate what's out there. And if you learn, like the story I told you about the dentist, that somebody else is out there using the same or similar brand name, there's an opportunity to negotiate a shared use agreement, as we discussed. that might take formal legal representation with a lawyer, but you can think about reaching out to that colleague and saying, I see you're out there operating a bakery across town and doing something similar to me. Can we work something out here? I'd like to resolve this. Because as I said earlier, if you sleep on your rights or you turn the other way, then that might actually be exposing you to greater risk later, because you didn't act vigilantly when you knew somebody was out there infringing, because arguably you waived your legal rights by doing that. There is such a thing as waiver in this space. And so I think that the good thing to do is to be vigilant, check what's out there. And if you're 50% of the way there, so to speak, it's never too late. It just means that you have more invested and maybe the stakes are a bit higher to make sure you negotiate a resolution that doesn't tamper or dilute, if you will, your intellectual property rights.
So this may be a bit of an unfair question, but I'll ask it anyway, because I know you're nice. Ideally, you have to get a lawyer, a good IP lawyer. But let's say that for whatever reason, you don't have the resources, but you still want to take some modicum of protection. Are there things you can do without a lawyer as a business owner that maybe not the whole way, but give you some sense of comfort or protection?
Yeah, absolutely. Starting with the publicly available information that you could search on your own. You could certainly hire a third-party vendor to run the search report for you. You don't need to go through a lawyer. Those folks will work with anybody who will take, who will pay their money. And by the way, just put this in perspective, we're talking about something in the neighborhood of $500 to $1,000 to get one of those search reports. So I would argue that it's probably a viable and worthwhile investment for most business owners. So in addition to the search report, I would think that even coming up with the most basic form of a written contract between you and whomever you do business with is very important. In a perfect world, you might probably want to consult a lawyer about what the laws in that particular jurisdiction permit you to include in that contract. If they are unreasonable and they're deemed to be an unreasonable restraint on trade, for example, then they may not be enforced. And so you want to make sure that it has teeth. But absent that, trying to draft your own agreement, putting down the basic terms of what your understanding is and what your expectation is probably better than nothing. Like having a contract of somewhat is probably better than having a perfect contract. And of course, it needs to be in writing. It needs to be signed by everybody. And then, as I said, calendar and docket a self-exam. So maybe you can't afford either the time or the money to consult with a lawyer right now, but maybe put it on your plan for the next year. Like make sure that on your birthday, you're going to treat yourself to having a consultation with your tax advisor and your lawyer about what should I be doing to better protect my intellectual property, my trade secrets, and the hard work that I have invested in developing this business.
You mentioned like these third-party services. I'm not sure that that's common knowledge for a lot of business owners. Do you have some names that you can name?
Frankly, I'm a little biased because we use a service called CoSearch, CoResearch. So that's one. I imagine there are others. I would Google third-party search vendors, to see who else is out there. Anybody who wants to can certainly contact me as a professional courtesy. I just give that information out. But I do think having a search report is a good investment. And at a minimum, doing your own search. There is publicly available information, as we talked about. And then there's third-party subscriptions, such as LexisNexis and assorted other subscriptions that are available to lawyers and non-lawyers, where you can actually set yourself up for an alert, for example. That is another service that my firm does. So if somebody hires my firm to assist them with a trademark registration, we set up an alert so that anytime somebody's out there using that name and it appears in some kind of public forum or on the internet, we get an alert so that the owner of that trademark can be vigilant and send out the appropriate notice. And sometimes it's called a takedown notice, for example, or a cease and desist letter.
One of the other things you said in the self-exam is you said go online and check. When you say that, do you mean I should just do a Google search of my brand name, or Are you talking about something more specific?
Yes, do a Google search of your brand name.
And then if whatever else that comes up that's similar is something that you want to research and see, is there a potential conflict or an infringement that you might need to take action on?
Absolutely. I mean, it cuts both ways. You want to see if somebody else is out there infringing upon your intellectual property, but you also want to be thinking about, are you about to invest further in a trade name that's already taken? It's not the end of the inquiry if your answer is, oh, yes, there is somebody out there. There are opportunities to negotiate a shared use, a licensing agreement, or maybe for all you know, that person is about to retire and they're willing to sell it to you. There's opportunities there. So I just think the information is good, regardless of what you do with it. And the thing about treating yourself every year on your birthday, I remember a trusted advisor told me once, the best thing you could do for you on your birthday is to think about how you're going to clean up your client base so that you have more space to take on the clients you prefer to take. I mean, it's similar to that. Be good to yourself as a business owner, take care of yourself, and treat yourself to getting good advice and being, a prudent business owner that's protecting your hard-earned money and emotional energy invested in that business.
Now, I do understand that there are different types of lawyers. There are general business lawyers, there are IP lawyers. How do you find the right IP lawyer? How do you find the right people? And how do you use that time to figure out if they're the right fit for you and if they know what they're doing?
Yeah, that's a great question. I think the best way to do it is to ask your other trusted advisors, your tax advisor, your financial investment advisor. Generally speaking, other licensed professionals can probably be the best source for telling you who are the best lawyers or other professionals with whom you may want to consult. I will also say that generally speaking, any lawyer who is worth her billable rate or his billable rate should be perfectly willing to give a complimentary phone consultation, regardless of how long it takes. I mean, within reason. For the first hour or maybe 2 phone calls that in total add up to 2 hours, you are courting each other. You're trying to evaluate whether or not it's a good fit, whether that lawyer with whom you're consulting can answer your questions, whether they're good at listening to you, whether they care about learning about your business, all sorts of those things. So I think trying to negotiate that preliminary consultation is very key. I would say don't rely on social media exclusively. That's probably an obvious recommendation. And don't rely necessarily on publications that say best lawyer, because as we know, people pay to be featured in those programs. I would say that particularly in this heavily litigated world, and by the way, there is a lot of litigation circling around trade secret and intellectual property rights. And it could become expensive very, very quickly. So it's therefore very, very important to rely on expertise and people who have been down the road with these matters and they know what they're doing and they don't cost you money later. So you might spend, for example, a few $1,000s on the front end evaluating and harnessing your intellectual property rights and protecting it from future infringement. But it's going to save you a lot of money down the road. And so think about it as, what am I going to get for this return on my investment? Is it worth it in the end? I rely very heavily on my other professional advisors, my CPAs, my financial investment advisor, maybe even my realtor or my dentist or my doctor. I do think there's something about licensed professionals that you're just familiar with, relying on the fact that you're operating in a very heavily regulated industry. And so you would then appreciate the nuances of how best do I get my trademark or my intellectual property protected.
And then do you have a list of 3 to 5 questions I should ask that give me a sense of, is this a good IP lawyer or not, other than the integrity and the willingness to work with you?
I would say ask the lawyer the simple question of, can you please better help me explain why it might be beneficial to me and my business to get my trademark registered or even to pursue this path? Help me understand why that would be valuable to me and why that makes, good business sense. I would also ask that lawyer whether or not they have had success in getting the trademark applications approved, if push comes to shove, litigating them. That said, not all lawyers do transactional work and litigation work in the intellectual property space. That doesn't mean they're a bad lawyer, but some people specialize in the transactional side or the litigation side, but not both. So you want to ask that question. You want to say, now, do you handle both the transactional side where you advise businesses and you help them with the application process and the registration? Or do you only handle the litigation side where you come into play when somebody's being sued or they want to sue somebody else? That's helpful information. And then I guess the third question is, don't be shy about asking for a budget. Say, I'd like you to help me formulate a budget. I want to know what the universe of expenses this might charge me and what are the factors that might change that budget. That's what I would ask.
That's probably a tough question. I know it would be a tough question for me, but it's good to know from the other side that it's an okay question to ask.
No, as a matter of fact, I would tell you from personal experience, I appreciate that question, because then it's almost like you're just talking about the big elephant in the room. Why are we avoiding the big elephant in the room? Let's talk about the elephant. And also you can help your client or your prospective client make an informed decision about, if they've dedicated, for example, $10,000 that year in legal expenses, how much of that budget do they want to dedicate to this issue? One other thing we didn't talk about that also relates to that is it's very important on the beginning end of this, and as you continue to grow, to consider what category of services and or goods you are going to be offering, because it could get expensive very quickly if you pursue trademark registration, for example, in categories that don't really apply to you. And also, you should be thinking about what category are you likely to get approved in, because you're paying per category. You're not paying per application. So that's another thing to think about and to talk with your prospective lawyer about. Say, do you have an opinion about, based on what I've told you about my business, what category of services should I be thinking about? And what will that cost me per category?
Is there a list of documents or pieces of information that a business owner can prepare ahead of time to talk?
I would like to know, help me better understand the services or products that you intend to offer. So identify the product and the services, identify your intended growth, both geographically and how many employees and who's going to have access, probably your retirement horizon. Like, what are you going to do with this business? Are you going to launch it, make it become phenomenally successful, and then try to sell it? Those are the type of things that I'd want to talk to my lawyer about. And what else you may have done before consultation with your lawyer to do your own due diligence. Why pay some lawyer to research information that you already have confirmed? So you're going to probably identify that as well. That's all I can think of right now.
Are there any other do's and don'ts as you work with your lawyer to protect your intellectual property that are good to keep in mind?
I would say definitely keep a record of all the effort and expense that you invest to protect your intellectual property. Maybe your relationship with that lawyer may end for whatever reason. He or she relocates, they retire. But establishing that historical database of what you've done from the beginning through the lifespan of your trademark, for example, as I said earlier, could help protect you and bolster your legal claim if somebody infringes upon it down the road. And as I said, sending a cease and desist letter, well, that too costs money. Maybe it's a few $100s or a few billable hours of a lawyer's time to send the cease and desist letter. It will pay off in spades because it's going to establish that you were vigilant. So one thing you might want to ask your lawyer, okay, you've prepared a cease and desist letter for me. Can I use this letter later to send to other infringers without you signing it? And any decent lawyer will say, well, you certainly could, but you should be mindful of the fact that laws change. Maybe the circumstances of the facts change, because who knows who else is out there using it, whether or not your trademark application has lapsed or been approved. All those factors can make that boilerplate letter you previously sent not obsolete, but maybe not up to date.
Achieve is dedicated to women entrepreneurs, and I'm sure you work with both men and women. Are there special things you've noticed when you work with women entrepreneurs that are different, and any special points of guidance or counsel that you'd give to women entrepreneurs?
I suppose this isn't necessarily unique to working with intellectual property lawyers, but generally speaking, I have found women business owners, particularly those who are bright and have invested in themselves, are often shy, if you will, or they lack the confidence that men do. We talk about the imposter syndrome and what that means just generally to females. But I think in this space as well, it applies, because women seem more reluctant generally than men to have confidence in what they have developed, in what they have harnessed, in their compilation of publicly available information, for example. So I guess my general advice is, think about how perhaps your male counterpart would be behaving in the same situation. Would they be, for example, reluctant to write a check for whatever it is, $2,000 to get a trademark application submitted on a federal level or a state level? Probably not, because generally speaking, men have more self-confidence than women do. So I would say that's the one thing. And the second thing is, be generous, as I think women generally are, of collaborating with other professionals in your space, particularly other females. I do think there's a lot of value in not just cross-marketing and networking, but learning from other people's mistakes and sharing those stories. It's valuable to others to think about and learn the path you've chosen and how you got there, and perhaps how you exposed yourself to the risk of liability without knowing that you were doing that.
And that's certainly what you have done, Lisanne. So thank you very much for taking the time to share all these valuable tips. Certainly been useful to me, and I know it'll be useful to many more people. So thank you so much.
It is my pleasure, and I wish you the best of luck.
Thank you for listening to today's episode. Find show notes and more at achieve.co. That's achiiv.co/podcast. Like what you heard? Hit subscribe on Spotify, Apple, or Google Podcast and never miss another episode. Want to help others like you? Leave us a review and tell a friend. See you on the next episode. Now, go achieve.